Hello guys, let's continue with what we left. So I guess I have to start from commentaries and digests. We saw that there were different Dharma Shastra texts that related to various themes, but it managed to touch each sphere of life at that time. What life at that time was, it managed to touch all that spheres, and various texts were written regarding the retirement of forest dwelling, renunciation or duties, powers of kings, how his court will be established, how the proceedings will be done in the court, all that stuff. Now, commentaries were written by commentators to interpret and provide meaning to the Dharma Sutra texts and Smriti, and each commentary devoted itself to one particular text. So commentaries, obviously it was written by commentators who had an impact and who had the role to interpret, to establish or to derive the meaning of the Dharma Sutra text and Smriti. Smriti is also a very important source of our Hindu law, right? Smriti means remembrance. Each commentary was for a particular topic. For example, there are commentaries exclusively on Manusmriti and on Yajnavalkya Smriti and so on. So on particular topic or particular theme, these commentaries were. Digests were not restricted to one text, but were arranged by topic or theme or subject matter and drew upon many different Dharma Shastra texts or Smriti to explain the topic. Now over here, they were not only restricted to one particular text or topic, but if the person had to write about a particular topic or particular Shastra which is mentioned in Dharma Shastra, then he will be going on various texts of Dharma Shastra and accumulating that information topic to topic. Okay, so it was not restricted to only one text, but topic wise or theme wise it was arranged. Like Dharma Shastra में for particular text, पर्टिकुलर टॉपिक ये चीज़ है, तो उस टॉपिक के नीचे जितने भी डाइजेस्ट होंगे उनको एक तरफ रखा जाता था. दैट इज बाय सेग्रीगेशन टॉपिक वाइज. फॉर एग्जाम्पल, देर आर डाइजेस्ट ऑन टॉपिक ऑफ रोल ऑफ किंग, इनहेरिटेंस ऑफ प्रॉपर्टी, रिलीजियस राइट्स, रिचुअल्स, adoption, litigation and judicial procedures. So these are various topics, and these are the topic wise segregation of digests. Then we have Anglo-Hindu law. Anglo-Hindu law divided into two phases. First phase is between 1772 and 1864. This phase starts in 1772 when British adopted rules for administration of justice in Bengal. So Anglo-Hindu law, two phases or two time frames are there for it. First is that began in 1772 with the Britishers adopting rules or measurements for effective administration in Bengal. Second phase is between 1864 and 1947. After 1864, India was formally part of British Empire, and 1947, everybody knows, India became independent. Important features are discussed below. So you see there were two timelines. First phase, in the first phase, three main developments occurred. First, the important Dharma Shastra texts were compiled and translated by various British administrator scholars including William Jones, Henry Thomas Colebrook, J.C.C. Sutherland and Harry Bordale. Now you see, within the first phase, there are three main or important developments that took place. Now, first one is when the British administrator scholars, they translated, they compiled the Dharam Shastra, means they considered our Hindu books and they read it, they translated it. The rules from these texts were applied to Hindus in order to expand British rule in India. So why they were doing that? So that they may know more about Hindu as a religion, their cultures, their traditions, their rituals, so that they may further expand their rule in India. Second development was the court pundits were used in British courts to aid British judges with interpretation of Dharam Shastra text and implementation of classical Hindu law. So second development was that the court pundits, means the you can say the high class people of the court or the educated ones, they they sat in the British court, so that was also for help to the Britishers, so that they may interpret or understand the Dharam Shastra text. They took the help of the Indian pundits, that you tell me what is written in this text or so, and then how can I use it to expand my rule in turn over all of the India. Third development is court pundits became redundant, means their influence or their part decreased due to sufficient proliferation and development of established case laws of some precedent value. Now court pundits, उनकी value कम हो गई because there was development of court precedents. British courts के precedents, judgments को ज़्यादा value दी जा रही थी. Second phase, departure from Dharam Shastra tradition is the most significant development of second phase. Now in first phase there were three main developments. In second phase, main development was that people shifted from the Dharam Shastra tradition. They left it, they shifted it. System of court pundits ended due to sufficient proliferation establishment of case laws. Since there were problems with implementing the classical Hindu law, British legislated and codified various laws or acts largely in form of English legal system or modern form of law. So now for the Britishers it was very difficult and not so easy to understand, to interpret and to implement the classical Hindu law. So they now themselves established or legislated a new one. They coded a new law that will be called as the English legal system, and then they implemented their own legal system. British felt that there were diverse customary legal practices among various regions and communities in India, and they were not necessarily administratively or otherwise connected with the idealized legal system of Dharam Shastra. So according to the Britishers, as we know, India is a very diverse nation. Till date it is. It has a vast diversity of religions, cultures, minority communities, traditional people, the tribal people, linguistic basis. India has a huge variety of people residing. India has a vast diversity. India is a land of diversity, you must say. So at that time, Britishers realized this fact. They recognized, they realized that there were so many diversifications in traditions, in legal practices among various regions of India and among various groups of people residing in India, that they were not necessarily and effectively implementing themselves. The Indian themselves were not necessarily and effectively implementing those legal system or legal texts of Dharam Shastra. So Britishers said that if they are not implementing it, we are also at a difficulty to understand or to interpret it. So let it be where it is, and we will bring a new one. British administrators undertook studies and compiled diverse customary rules practiced among different communities. These were consultative resources for courts. Now Britishers, they did a study, the British administrators, scholars you can say, They undertook various surveys or studies and compiled the diversification or the various diversity rules or customs that various groups of people were practicing of that time. And so that customary rule was sort of aid or help or consultation sort of thing for the courts, that these are the traditions, and keeping that in mind, now you have to give the verdict on keeping these traditions in mind. You may adopt a policy or so that they will be impressed and you may rule it in turn more efficiently. By and large, idea of English legal system was well received by Indian nationalist movement and was adopted after India's independence from Britishers. So as I say, that it's not always the bad impacts that Britishers had left over us because of their rule, but some good things India has taken. So India's administration, that is the way it is being administered now, a lot of impact of that has come from UK, right? So the English legal system that the Britishers had framed at that time, we after independence had adopted that, we received it with full heart, we agreed to that type of governance, and till now it is being implemented. Now we come on to modern Hindu law. British adopted modern law or English legal system and replaced existing Indian laws except for laws related to family or personal matters. We did this. We read it before also. They implemented everything, but they hadn't touched the marriage, inheritance or such family related matters. Family law or personal law applicable to Hindus is modern Hindu law. So what they had not touched, जो हमारे पास बचा, जो उन्होंने जिसमें उन्होंने amendment नहीं किया, that is what is part of modern Hindu law now. Indian Constitution of 1950 has adopted this arrangement wherein family or personal matters, customary laws of relevant religious groups or traditional communities apply. So the family or personal matters के लिए उनके religion का एक personal law उन पर apply करता है. हिंदू पर हिंदू लॉ एक्ट करता है, मुस्लिम्स पर इस्लामिक लॉ एक्ट करता है. तो हर रिलीजन को रिस्पेक्ट देते हुए इंडियन कॉन्स्टिट्यूशन ने उनके पर्सनल मैटर्स, फैमिली मैटर्स के लिए उनके रिस्पेक्टिव रिलीजियस या कस्टमरी लॉज को अडॉप्ट किया है. During early 1950s, some parliamentarians and groups had suggested some kind of return to classical Hindu law with one uniform family law for all communities. That is what it is known as uniform code. That it is the same code or the same law is there for each and every resident of India. चाहे वो किसी भी religion का हो, but same law will be applied. Family law, same family law would be applied for all the communities. There was no unanimous support. Unanimous means not everybody had agreed in the affirmative. किसी ने, सबने कहीं भी हाँ नहीं बोला. अगर 3:2 का रेशियो है तो 3 ने हाँ बोला, 2 ने ना बोला. अगर 5 लोग बैठे हैं, 5 ने हाँ बोल दिया तो उसको कहेंगे यूनानिमस सपोर्ट था. 5 के 5 ने हाँ बोला तो वो होगा यूनानिमस. ठीक है. So there was no unanimous support and it was turned down. जब उसको support नहीं मिला, जब उसको majority का support नहीं मिला, तो this proposal was closed. In 1955, Parliament adopted 4 major legislations governing family and personal matters of Hindu community. Hindu Marriage Act, this is very important. Hindu Succession Act, Hindu Minority and Guardianship Act, Hindu Adoptions and Maintenance Act. These codified laws are first points of reference for modern Hindu law. Although family and personal laws are different for various religions and traditional communities, courts that adjudicate these matters are common, that is state-run family courts. Whatever it may happen that there is a person of Hindu religion or Islamic religion that come to the court for family related matters or such matters, marriage, inheritance, property matters. That is the family matters, that is called the family matters. तो चाहे किसी भी रिलीजन का बंदा हो, लेकिन कोर्ट तो एक ही है ना. The court where they go for resolving their dispute, that is common, that is same. Judges presiding over the matters are common for all communities, and they may not belong to those specific communities whose matters are presented. It may happen that the parties to the suit are Hindus, but the judge who is deciding over the matter is a Muslim or a Christian or whatsoever. Also, the state judges have no formal religious legal training about various communities they adjudicate. They are not trained, the judges are not trained that how you need to talk to the people, how you need to address to the people. They are not trained for such things. They may not be trained, or they may not specialize in your religion. Right? Islamic law is the last topic of this chapter. First Muslim settlers arrived in India in early 7th century AD. Then Arab merchants came to Malabar coast in South India. 12th century, the Turkish invasion brought Islam to India. Now you see the first Muslim settlers, these are the various timelines that are given. Nothing much to explain in this, so I am going or reading over it. Turkish invasion brought Islam. So what brought Islam to India? That may be a question. And when? In 12th century, when the Turkish people invaded India. Later, with the advent of Mughal Empire in mid-16th century, Mughal judicial and administrative systems were introduced in India. When Mughals ruled over us, their own system or their own format or the way of ruling, that was then introduced. Mughal court systems were later replaced by English legal system. Mughals के बाद English आया, English अपना लेकर आए, so the Mughal systems were replaced by the English systems. When British adopted rules for administration of justice in Bengal. Now, the last section on family justice system covers Islamic law in India and civil law matters of marriage, inheritance and other personal law issues. This chapter is done.